Do you think life is simpler as time evolves? For some, it can be more complicated when facing issues about health, estate plans, probate, long-term care, and more. That's why Attorney-CPA Joe Cordell hosts ElderTalk with TuckerAllen, providing intelligent answers for those thinking about their future. Here's Attorney-CPA Joe Cordell.
Welcome to another episode of ElderTalk. This week, we're going to return to a topic that we return to periodically, and that's the subject of how do you qualify for Medicaid coverage to take care of your long-term care. And some of you have very little idea kind of what this conversation pertains to, how it's relevant to you, so we want to start out by talking about what those general rules are. But our intention is probably to take this over 2 shows. Is that right, Jill?
That's right. This is segment 1.
So we'll take it over 2 shows. And I think if you invest the time to watch these 2 shows, you'll have a very good working knowledge, far above that of most people in the United States, as to how it is that you qualify for this wonderful benefit for those of us who will need it. And statistics tell us that the substantial majority, what was the last number I heard? That there will be like 67% of people spend some time in long-term care, and
right.
I think that's an old number. I think it's probably higher than that. It doesn't mean that 67% are likely to spend 10 years in long-term care, whether it's specialized care, whether it's assisted living, but it does mean a substantial period of time, and I don't remember what those barriers were. It's probably about a minimum of 30 days, maybe a minimum of 90 days, but it's substantial, and we can only expect those percentages to go up. So it's relevant to all of us, if we end up being in that minority who's going to be in long-term care for a long time, then how do we pay for it? And can we possibly keep some of the assets that we've accumulated? So this is a good place to start. And we have with us today the attorney to whom we regularly turn to answer questions such as this with TuckerAllen, Jim Gau. Jim, are you ready to discuss this topic?
As ready as I'll ever be.
Okay.
It can be very complicated, but what gets me is so many people don't realize that this program is available to them.
Well, yeah, or they've kind of heard these buzz phrases, but they don't get it, and they don't see how it's relevant to them.
Right.
But you're right. They assume that they have to be completely broke in order to qualify for something called Medicaid. And Medicaid, of course, has all these unfavorable associations. It connotes, a free ride, or it connotes a lot of things that trouble people who have accumulated assets. And they feel that somehow they shouldn't be. It's not right for them to try to qualify. Why don't you set the stage, Jim?
Right. So you hear clients come in and, they've saved their whole lives. Most people don't ever think they're going to go into a nursing home. They don't want to go into a nursing home. They think their kids are going to take care of them. Sometimes the kids think they're going to be able to bring mom and dad in and take care of them. And it's just
not always possible.
It's not that easy to take care of an older individual. And it's just a lot more intensive, all day, everyday work that can really only be provided by skilled nursing. And you're right.
Or assisted living.
Or
too.
assisted living, right. And you're right. It has a lot of negative connotations that people don't want to take a handout. We've worked hard our whole lives to save. Why would we want the government to come in? And on the flip side of that, there's the same amount of people on the other side that say, the government's going to take my money if I go into a nursing home. Well, that's not really how it works.
Yeah.
But that is what people do say a lot. I don't want the government to take my money. So yeah, you're right. It's got a lot of negative connotations, but
so give in very broad outlines, in the broadest of outlines, explain what the deal is, how it works.
Okay, so once you're below the qualification numbers, which we'll go over probably later in the show, you can apply for government assistance and subsidies, basically, to pay for part of your nursing home stay.
And it's mainly nursing home.
Right.
We'll talk more about that. Go ahead.
So you're still using your Social Security income, your pension income. All of your income gets applied to the nursing home, but it's not ever enough. Nursing home stay is $7,000-8,000
Very
a month.
expensive.
In
yes.
St. Louis, $10,000.
Yeah. And people don't get that in Social Security. I've never seen a Social Security check come in that's $7,000 a month.
And some people, I think, are under the assumption that Medicare will take care of that. And that's not true, correct?
Correct. So there's a lot of confusion between Medicare and Medicaid, and rightfully so, they sound exactly the same. Medicare is for short-term rehabilitation stays. So if you fall, break a hip, go to a hospital and, have a 3-day stay, you get 100 days worth of Medicare coverage to rehab. Now, that is as long as you're continuously rehabbing and getting better. So the doctors can at any point say they're not getting better. They send a letter to Medicaid, and Medicaid sends a termination notice saying that they're going to stop paying.
Yeah, and people have to get this distinction. Remember, Medicare is for health insurance. And when we're talking about people in long-term care, especially in a skilled care facility,
right,
that's not really any longer about health insurance as normally understood. The way health insurance normally works is it provides for anything that's necessary to treat an illness or injury. Treat, meaning with the intention that you're going to improve that condition. At a minimum, maintain it, but especially to improve, there's going to be some hope of recovery. That's medical treatment.
Right.
When you have long-term care, it's more of the nature of a custodial arrangement in which you need a whole lot of custodial care, and that's almost a cost of living at that stage. So except for the 90 days or 100 days a year that you can potentially qualify for things involving rehab and things from which you will improve, et cetera, except for that exception, you're pretty much on your own to pay for your skilled care costs, which, again, can easily be $10,000 a month. I would argue, I routinely say whenever we're having this conversation, assume $15,000. I mean, at the rate of inflation we have today,
right,
not everyone's going to stay here in St. Louis. So even if St. Louis did stay at 10 or 11 or 12, we know many parts of the rest of the country are already 15, 16, 17. So assume you're talking about $15,000 a month. And if you do your math based on that, it's going to be more realistic if we're talking 5 to 10 years in the future. So the good news is the big picture of this discussion is we're going to talk about a way that you can have some assets, you can keep assets, and still have these costs paid. In the alternative, explain the alternative rule if they decide to qualify for Medicaid alternatively.
You mean as far as planning, or
how broke they have to be? I mean, what is the other plan?
So it's either plan or spend all your money until you are what normally people think of as qualifying because you've got no money. So in Missouri, for a single person to qualify for Medicaid and go into a nursing home, you have to have less than $5,000. It used to be $999. They've gotten a little more generous, but it's $5,000.
And that means that someone that say has a lot of assets, they're very well off, they have accumulated quite a savings account, they can still qualify if they manage their assets correctly.
Right. So the $5,000 is assets in your personal name for the last 5 years.
In other words, with no planning. If you ignore this show, if you decide to go to another station to watch, then you can plan on keeping $5,000 and still paying a hefty tab for long-term care. So if we're talking $15,000 a month, it's not at all inconceivable that you or a loved one or a spouse could spend $300,000, $400,000, $500,000 easily. So when you're talking about consuming that, and you're prepared to do that, then you may choose not to plan. But most of our clients want to plan because they think, why should I spend that $500,000 for that coverage if I don't have to? So if you talk about 10 years at $150,000 a year, I mean, let's use that example. That assumes $15,000. Let's do it 12. $12,000 a month, which we are at in St. Louis in some areas. So 12 times 12 is 144. Call it 150. So 10 years, $1.5 million. So now, if you only have $20,000 in assets, you're saying, well, wait, that's only $15,000 and I get to keep $5,000. But I know most of this audience is middle class. And I know most of this audience probably has somewhere in the neighborhood, including your home, of, say, $400,000 to $1 million. it's not at all unusual to have $1 million at this stage and still be middle class because you've saved, you've been frugal, you've invested conservatively, cautiously. So are you willing to dissipate, I use the word dissipate, spend, are you willing to spend that, whatever it is that you've accumulated, that $800,000, when all you had to do as an alternative, you could have hired a law firm that focuses on this area. We're not supposed to say specialized. You could hire a law firm that focuses on this area of the law, use the law to your advantage, and guess what? You could potentially keep your $800,000 or your $500,000 or maybe even your $1 million and still qualify for this coverage. That's not abusing the law, incidentally, and we should probably speak to that just for a second. It's not an abuse of the law. It's like tax law, isn't it?
It's exactly. If you claim all of the allowable deductions on your tax return, you could say that you're cheating the government, but you're not. You're using the law the way it's intended. These laws, the exemptions, the deductions are in there for a reason, and you do the same thing with Medicaid. We know what the law says. We play by the rules and plan to protect your assets.
It's not like you're pulling some sort of a scam.
No, we're not, taking a sack full of cash and putting it under the mattress and not telling anybody about it, burying gold bars in the backyard. We're playing by the rules.
As a matter of fact, we're conservative. If you want, there are all law firms out there that decide to test the outer boundaries of the law at their client's expense. And I'm not saying it's unethical as long as they disclose to their client that they're doing things that are risky and it's not been approved yet, though they have an argument. Those are the cases where they end up going all the way up to the Court of Appeals and they make the lawyers famous, but the client's generally out about $300,000 in legal fees and at least a 50% chance of losing. We don't want our clients to be in that position, so we're conservative. We're only going to do strategies of planning such as this where it's well-settled law. We're not breaking any new ground here. We plan like we'd want to plan for our own families. So what we're going to talk about in these two shows are things that are not real novel, I'll tell you. Authorities in this area, people who practice regularly and doing Medicaid planning, these are standard techniques and procedures, and they've been tested. Now, let me tell you, the law does change, and sometimes it changes more rapidly than we'd like. So we do have to keep track of what new rules are issued out of Medicare and what is it? The agency,
Department of Health and Senior Services.
Yeah. Well, that's on the state level, Health and Human Services. Yeah. But Medicare and Medicaid Services, what I was trying to think of, which is that's the department that administers both Medicaid and Medicare. So now that we've kind of introduced what's at stake here, why this is a worthwhile thing to talk about, let's kind of go to the next level. Let's start by pointing out things. There are some things called exemptions, but you have to treat with care that word, because exemption often means entirely excluded, entirely protected. In this case, exemption is better described as qualified exemption. So let's talk about what the general exemptions are in the state of Missouri.
Right. So that whenever you talk about Medicaid qualification, that $5,000 number you have to be below is countable assets. So there's countable and there's non-countable assets. The non-countable assets are what we would consider the exempt assets, the exemptions. And that's going to be your house, as long as you're living in it, one car, personal belongings. I think the family Bible is actually listed on there.
Are you serious?
I think it is, yeah.
I think
absolutely.
it is in Missouri.
Yeah.
Family Bible,
that goes
really?
back to protections in bankruptcy.
Okay.
Yeah.
Yep.
Wow.
An automobile.
Yep.
I think $1,000 of whole life insurance. Or something?
It's and then prepaid funerals are also exempt. Yeah, so they want you to be able to pay for after they're done with you. They want you to have a small, like you said, a small amount of life insurance, but death benefit. If there's no cash value, the life insurance is exempt. It's really they just want the cash value. But you're right, it's a small level of cash value is exempt.
So you can see that if we're talking about numbers of $500 to $1 million, which for many of you might have that saved by the time you leave this world. This is not very exciting, what we've just said, these small numbers. And even the house, which could be a big number, even that is not quite what it seems. Explain the rules relating to the house.
Yeah, so if Medicaid pays for your care and puts money out and pays the nursing home, they can file a lien on your house, a security interest against your house, like a mortgage. But it's the state of Missouri filing a lien for the amount they've paid for care.
And is that after your death, or can they do it while you're being cared for in the nursing
So realistically,
facility?
the way it kind of shakes out is the state pays for care. The client then dies, and the kids say, oh, great, we've inherited the house. They go to sell it, and they realize, oh, the state of Missouri has a lien on it. That's just great. Now our big inheritance, the house, is worth half of what it actually sells for.
But there's exceptions with that. If there was, say, an adult child that was taking care of an elderly parent, an ailing parent for a significant period of time, there's that exemption, right?
So if a child is living in the parent's home, caring for them.
Not a minor child, I'm talking adult.
Adult, yeah, right. For 2 years, then the parent can transfer the house to the child. And the logic behind a lot of these is while the child was caring for mom or dad, the state wasn't having to pay for nursing home care. They were prolonging the stay at home, saving the state money, so the state kind of allows them to save the house that way.
Now, how does the state know that that child's telling the truth? I mean, the child could come and say, oh, yeah, I've been caring for mom for 5 years. Do you have to prove that?
And it's the same way you would prove residency. So we've shown pieces of mail that say, look, adult child was living with parents for all the way back to this date.
And a good thing to keep in mind on this as to any of the documentation associated with things we talk about here is the burden of proof is entirely on the person seeking Medicaid coverage. So keep in mind that at every turn, such as qualifying, proving your income, proving your assets, on those occasions, be prepared to bring lots of documents. And we're going to talk about transfers and look back here in a little bit. And again, as to those things, it's your responsibility to come up with the documents. Burden's on you. If there's not evidentiary proof, then you lose, not the state. So on this subject, yeah, you do have to provide proof, but generally it's not hard. I mean, if you show evidence of bills, of mail that was coming to the house, so usually that's not a big deal to prove. There's a very similar rule regarding a sibling, right?
Right, but the sibling has to be a co-owner of the house. It can't just be living there like the child can. So yeah, they're a little bit more lenient on a child than they are on a sibling. There's a little bit more burden of proof on a sibling.
And isn't it true that if the child, say, has some sort of disability, there's that exemption?
Yeah, for
Is it if they're
special needs trust?
So if there's minor children or children that were disabled their entire lives, that gives it a little bit of there's an exemption for that as well to protect the child.
Sure.
Yeah.
It's the same reasoning behind the spousal exemptions. If a spouse is at home, then they get to keep more assets and some income, and the house is protected that way too.
Right. They won't go after the house until the spouse of the person in the nursing home passes.
Or goes into a nursing home.
Or goes into right.
Yeah. So keep in mind, though, whenever you hear about real estate or a house being exempt, that means that it won't be taken as long as somebody is living in it and on Medicaid. Now, that could be you. There's actually Home and Community Services Medicaid where you get kind of coverage at home that's paid without you being in an actual nursing home. We won't spend a lot of time talking about it, but it's the same idea. So if you're in your home, if a spouse is in the home, if a dependent or an adult dependent child is in the home, then they can continue living there for the balance of their lives. But don't confuse that to mean that the house is free and clear. Because as Jim just said, there is a lien against it. It's called asset recovery. All the states do it. And if they don't do it, they will lose this federal contribution to Medicaid coverage in their state. Big deal. 50% at least of the approximately 50%, it varies from state to state, is paid by the federal government for all these welfare or Medicaid services. So in order for them to keep getting that, they have to do asset recovery, and they have to do it vigorously. It's done through the Attorney General, the state Attorney General's office. So that means that if you don't lose your house today, you would lose it when you pass away if you didn't do any planning at all. So I think that you need to keep in mind that whenever we're talking about reasons that you should consider planning, it includes the equity in your house as well as your other assets.
Mm-hmm. Yeah, the good thing is the rules that we play by. The state of Missouri actually has a rule that says as long as you intend to return home, the home is exempt and they can't put a lien on it. And so
intend to return home from the nursing facility.
Exactly, yeah. And so we've provided affidavits from clients that say, absolutely, I do not intend to stay in this nursing home the rest of my life. I am going back home. And I've heard stories even going so as far as, the last week they go home for hospice and then they have returned home and the lien gets extinguished because they've actually returned home. Now that's a little crazy.
Yeah.
To be taking a pretty sick and dying person back home just to save the house.
It's like people when we were changing over to a new tax law that was going to affect about 10 years ago, and people, if they died in the following year, it was the year when we had the expiration of the estate tax, and before the new one was kicking in. So we went through a year in which I guess the old regime reverted, which was really low. So they were keeping people on respirators and whatnot to keep them alive so that they actually pull the plug, after midnight on the 31st of December.
That was happening just last year when we were getting ready to change presidents potentially. People were worried that the new administration was going to come in and change all kinds of gifting rules and eliminate the step-up in basis, which is still a thing, and eliminate the estate tax. So there was all kinds of gifting in 2020 and 2019 because people were trying to use the $11.7 million exemption and claim all their lifetime gifts against it before it went back down or disappeared.
Yeah, the world is changing, I'm telling you. And it sounds kind of morbid, but when it comes to estate planning, it's all based on often some sort of timing if you think the law is going to change. And even when we talk about this subject, while it's not morbid in the sense of planning when someone dies, it is important to do look backs. And this is an area we really need to spend some time talking about, because it's one of the biggest obstacles, not an insurmountable obstacle, incidentally, but it is an obstacle that has to be considered and whenever we're doing planning. And a lot of people have heard of this, the idea that the Medicaid qualification means that they look back a certain amount of time. Let's talk about those rules.
It's a 60-month, 5 years look back period. So you mentioned earlier that the burden of proof is on the applicant. You should see the thickness of one of these Medicaid applications because you have to provide 5 years of bank statements, 5 years of for your investment accounts. I mean, 5 years of statements is by itself a 1-inch binder. And so you've got to provide that for every single account. And they go through with a fine-tooth comb and look for transactions that look suspicious, that are over, checks written over $600, ATM withdrawals, you're taking $1,000 out a day. Well, what was this? What were you trying to do here? Let me see the mattress.
Right,
yeah.
right.
And so they go through, and it's 5 years of bank statements that you've got to provide.
And you may think, okay, well, maybe I can do it in form of transferring assets. But anything that's going to make its way to your one of your tax returns is going to be evident. If you think about it, in this world where things are connected, they're digital, it's documentary, the days when you barter with things on the street, there are no documents of title, et cetera, that applies to very few transactions in the modern world. So you may think that a lot of transactions will escape notice. The reality is it's unusual for them to escape notice. By the time someone demands all of your tax returns, all of your bank accounts, your securities accounts, anything that would evidence an asset with a title, then the probability is if you've engaged in any transaction for less than fair market value, then it's going to be considered. And I got ahead of you there. Explain what the rule is.
Yeah, so let's just think of something as simple as the house. It's usually people's largest asset, and it's something they want, the family home. We want to protect it. We want the kids to get it. So you try and just deed that away. Well, if you deeded it away 3 years ago, they're going to do a title search, and they're going to see, well, you had a house. It was valued at $350,000. You transferred that away without consideration. So what we're going to do is we're going to penalize you. $350,000 divided by, let's see what the Missouri penalty divisor is. $350,000 divided by $6,588, and then you get that's how many months you have to privately pay before Medicaid will pay.
So they prorate it.
Yeah, yes.
Basically, because there wasn't that 5 years.
Right. So, I mean, you made a transfer out of your estate. If it's cash, you got to get the cash back. If it was an asset that wasn't liquid, you got to figure out how to get cash to make up that penalty. But yeah, I mean, they'll.
And let me make this clear, because I know it's real confusing. Whenever you have a substantial amount of assets and you would like to be able to have long-term care paid for by a third party if you can, which is the purpose of this conversation. If you didn't have such a rule, you could take this $500,000, transfer it into a trust of some sort. It'd have to be an irrevocable trust, meaning there has to be some meaningful way in which you've given up control. Be suspicious of any lawyer who suggests to you that you can transfer assets when you're trying to meet a legal requirement in a way that you still have complete control. You should be very suspicious, because the law has a lot of common sense, believe it or not. So you think that's a bit of news, and it looks that way. But for the most part, the law does have a lot of common sense. So it says there has to be a meaningful transfer. So an irrevocable trust is a way of which you do a meaningful transfer. If you could do that today and make application tomorrow, then first of all, you wouldn't have lawyers being hired to do this complicated planning, and people whose specialties or whose practices are devoted to this area. That wouldn't exist because people could easily do it. Maybe you would have lawyers just form a trust for you. But it's not that easy. And it was 3 years up until 2007 or so, right?
I think so. Yeah, that sounds about right.
For what, look back?
Yeah, the look back was 36 months. And then it went to 60. So what we're talking about here is the fact that anything that you did where you transferred an asset and got it out of your name, which means filling out a form and applying for Medicaid, you'd have less assets. It means you would sooner qualify. So how do you deal with this 60-month look back? And I want to also comment on how this is calculated. I'm going to say again what you said, just so people understand it. So what Missouri does is they have an average that they spend on Medicaid or specialized care services in this state. Every state's will be different, so they just take an average. And so if it's $5,000, and in fact it's what,
$65.88.
$65.88.
That's that top number.
Wow, it's moved up, and it is adjusted regularly. So let's call it $10,000 for the sake of discussion. And you gave away $500,000. You transferred it to a trust. Don't give it to a child. Don't do any of those.
That's a red flag.
I can tell you, worse than that. It's a really bad decision, right? From a legal standpoint. It's an awful decision. It has tax ramifications, creditor-debtor issues, liability. So that's not an option. When we talk about gifting, almost without exception, we're talking about gifting to an irrevocable trust in which you will still have some level of control. Don't interpret what I said a while ago to mean that when you transfer an asset to an entity like this that you lose all control. That's not true. But you have to give up a meaningful amount of control. But anyway, we're talking about moving, in this case, let's say it's $500,000. If you divide that by 10,000, so it means, what, 50 months?
50 months.
So 50 months you would have to wait from the time you were otherwise qualified. You'd otherwise be qualified to enter into, that's the starting point. You'd otherwise be qualified to enter into a long-term care facility. You don't have to actually enter, but you have to meet the criteria in terms of your physical condition, et cetera. And then the clock starts ticking. So just think, you have to wait 50 months before you're going to start getting a check. That means you're paying out of your pocket, presumably, for 50 months. So that's the magnitude of this issue. So we're talking about something that can make an incredible difference in your life. I mean, incredible difference in your life by this planning.
Right.
Well, I just want to make sure I'm clear on something. So say you create this irrevocable trust today, and you've got everything lined up, and 3 years later you have a stroke and you have to go into a long-term care facility. You haven't met that 5 years. So again, they prorate.
So
or what happens?
The bulk of Medicaid planning is planning for exactly what you just said. It is planning on how are we going to make it 5 years and still protect assets. So what we normally do, and in fact, I met with, oddly enough, 2 clients yesterday that we had this conversation about. So they both had long-term care insurance policies, and the long-term care insurance policies were right at 5 years. And so I said, the day that you start using this policy, you already want to have your Medicaid planning done. You want to have that irrevocable trust set up because we know how you're going to make it through the 5 years. You're going to use this policy. We don't know what we're going to do when that policy runs out. And that's when so if you plan on day 1 of using the policy, 5 years, you're going to make it through the look back. But then when the day after that policy expires,
right,
we can apply for Medicaid. And so the planning really is, and it sounds crass a little bit, not really crass, but it's a math problem is really what it ends up being. And so we know you've got X dollars to your name. If we put X dollars in this trust and leave X dollars out, we know we're going to make it to a break-even point somewhere along the line.
Now, would spend down include something, say a grandparent gives their grandchild money for tuition, and you have proof that it was actually paid to the university? It's not just you writing a check to your grandchild for $30,000.
So that's a gift. You gifted the money away. The best way to do spend down is, well, the fastest way is to pay for the nursing home, but make improvements to exempt assets. So we said the house was exempt. House needs a new roof. There goes $20,000. The car, I'm driving an '86 Dodge Stratus. Well, okay, let's get a nice new car that's exempt. Let's prepay our funerals, $15,000 for each person. So there goes $30,000. So that's the real spend down. Paying for kids' tuition is, you might as well have just handed them a check.
Okay.
Yeah.
It's a gift still.
It's still a gift. Okay.
Yep.
Now, what happens if someone tries to fraudulently claim that their loved one has no assets and say they get away with it in the beginning, without notice? Medicaid still does look. I mean, it could be months down the road, and you can get caught.
Yeah. I mean, it's fraud. It's
Well,
a felony.
it is.
Yeah, right.
So, I mean, you would possibly could face criminal charges for something like that?
Oh, yeah. I mean, if somebody intentionally intentionally misrepresents the amount of money they have, it's probably going to be in excess of the fraud limit, which I think, or felony limit, which I think is $5,000. So they'd be looking at a felony. I mean, if you intentionally commit that sort of fraud, it's Medicaid fraud, and people go to jail for that. So, no, we're insistent that our clients play by the rules.
Yeah.
But the whole idea is that if they do play by the rules, often there are ways to qualify. And one way is people who, and you made reference to this, and this is marvelous, when people come in and it's not an emergency scenario, meaning that they kind of see problems down the road. Maybe one of them has been diagnosed with Parkinson's or something where they think there's a chance, an increased chance, that one of them may need long-term care, and that could last for a long time, depending on circumstances. So for that person to come in, and it's a great opportunity for them to go ahead, do the planning now, and to do transfers now, recognizing that they want to get as close to 60 months before they ever have to call on this sort of Medicaid qualification. So it might be that they only get 40 months. Well, it's still marvelous. It's not like jumping from one cliff to another where if you don't get, if you're an inch short, you might as well have not jumped. Whereas in this case, whatever you're short, you still save the money. So let's say that that they come in, one's been diagnosed with an illness, or maybe they're just older, and they know stuff happens. So they've decided, we want to take some of our money and plan this way. So they may have $1.5 million. And it's kind of unusual unless you have pretty clear clouds on the horizon that they put everything into, for example, an irrevocable trust.
So that's almost, it's red flags because you've made this large transfer, and it's almost, you can almost imply the intent to defraud someone. I've completely bankrupted myself funding this trust. So they should keep enough to live. They know they're going to have to live 5 years, so they need money to live on for 5 years.
Yeah, right. But tell me if you disagree, though. It's okay to do that as long as you document the transfer and you have a means of living. So if you have a source of income and you've given away all of this and it was beyond 5 years, unless the laws change, it's fine. Perfectly clean.
As long as you're not transferring all your assets one day and then the next day you're filing for bankruptcy and collecting welfare.
Well, Jim, what is the average age that someone starts planning for Medicaid? Because I can't imagine somebody coming to your office that's 40 years old and wants to create an estate plan and is thinking about nursing homes.
It depends on a variety of factors. It depends on their net worth, number one. If they have enough money that they know they can put away $1 million or $2 million and not even feel it, then they may plan earlier. But that is going to be more, I see that more as an estate tax plan or a gifting to my kids plan rather than, which it works. It still is the same kind of planning, and it's still going to involve irrevocable trusts and could still work for Medicaid planning, but that's not at the forefront of their mind when they're that young. Usually it's retirement age kind of people where now our income has drastically declined and now we don't know how we're going to pay for a nursing home.
And I'm sure you probably have heard this before. People might perceive that they won't get quality care if Medicaid's paying for their stay at a nursing facility, but that's not true.
No, I mean, there are very, very nice nursing homes in the St. Louis area specifically that take Medicaid and have Medicaid beds. I think Del Mar Gardens is one of them, and that's one of the nicest.
They do.
But the law forbids that discrimination.
Right.
So whatever quality of care they give to anybody in the facility, they have to give to everybody. So I'm not. Whenever this subject has come up before, I'm not suggesting that there isn't an occasion when that occurs somewhere in some nursing home in Missouri or any other state, but family members who are at all on top of it, and those are the ones who get their loved ones get the great care, is when you have people drop in, and that's true for almost any facility.
Sure, absolutely.
So, but the law's on their side. I mean, if they're being shortchanged in any way from anybody else in the nursing home, then they have a cause of action, and the consequences can be severe. So, I won't dismiss it because I know it might occasionally happen, but I think it's very unusual, and there's no need for it to happen. Let me complete though this point I was making a moment ago. So if you have say $800,000. And you've come in, you have this expectation that perhaps there's going to be a problem down the road, but you don't want to put all of your assets in this irrevocable trust, which has some limits on it, as we talked. So you might put half of your assets in there and say, whatever happens, I at least know that these assets are going to be completely safe. And another good thing is you use some of the other money in the event that you don't make it quite the 60th month. So let's say that you make it 40 months and something happens and there's a stroke or whatever it might be. So in that case, you have to pay 20 months out of your pocket. So if it's $10,000 a month, I mean, you're out that $200,000. But the good news is, once you spent that money and you get to the 60th month, now you pass the 60-month look-back test. So the rest of whatever assets you transferred back 5 years ago, those are protected. So that's a way maybe to think about this conversation. Don't think of it as all or nothing, that I'm either completely exposed to having to use all of my assets, or I have to take all of my assets and do some sort of transfer with them. That's not true. Most of our clients, the vast majority of our clients, will take a portion and do that sort of planning with it, and then they'll take the other portion and do different planning.
Well, and let's just think of the worst possible case scenario, that family comes into our office and they say mom or dad is going in right now. They're in the car. We stopped on the way to the nursing home to do this planning. You know, let's say it's $10,000 a month. We need $600,000 to last the 60 months. We have $2.5 million. Okay, we'll put $1.9 million in an irrevocable trust. We'll spend $600 over 60 months. There we go. And then at that 61st
Problem
month,
solved.
You've saved $1.9 million, or the number that I actually said a second ago.
Yeah, that's a good way to think about it. That's probably a better way to explain that, is to imagine that you need to get coverage today. So you have to plan on paying for the next 60 months. But then anything else, though, you can move to a place of safety and know that, well, whatever happens after the 60 months, it won't be making a claim on that money.
Right.
Yeah. Now, what about, though, when we have this crisis scenario? Let's talk about some of the other options. We talked about what's called a spend down, which is not entirely satisfying, but to the extent that you use the money in lifestyle yourself, it's not a gift. To the extent you spend it on your house, which, remember, that's not an entirely satisfying approach, because there's still a chance that house will someday be sold for asset recovery. It's not certain now, because if you have a spouse that survives you, continues to live in the home, sometimes historically the state's lost track of that. And
Right.
sometimes it doesn't show up in the death of the surviving spouse. Or it might have been transferred during their lifetimes by way of a deed or a beneficiary deed, something in which it wouldn't end up in an estate. We should take a second now and talk about, though, how aggressive we sometimes see states of Missouri being. There's a specific law, is there not?
There is. There's a statute that allows it allows any creditor of an estate, but it was specifically drawn up. I bet if you look at the legislative history of this law, it was geared towards Missouri being able to do it. But so non-probate transfers are transfers at death that don't have to go through the probate court. So for those, you're talking about beneficiary designations, transfer on death, pay on death, beneficiary deed to the house. And the Missouri has a statute that allows creditors to go after those non-probate transfers if they have a claim against the estate. So the state can use that to actually pull in non-probate transfers. So if you have a beneficiary deed on your house that says everything goes to the kids, the state of Missouri says, hold on a second. We know it's in the kid's name now, but it wasn't when we were paying for stuff, so we're gonna pull that back into the estate for our recovery efforts.
So do they go after the kids then that inherited a house?
They do. So, I mean, the kids are going to be drawn into the estate just by manner of being heirs. So they'll get notifications and stuff like that too. But yes, they can pull that property back into the name of the decedent to recover from it.
Yeah, like a fraudulent transfer.
Kind of, yeah.
Mm-hmm. Now, what if someone was receiving Medicaid throughout their life? And I'm not talking for a nursing home, it was their health insurance. Does Medicaid then go after any assets you may have when you
I've
pass
never
on?
heard of I think when you're collecting Medicaid in that circumstance, I don't think the state, number one, I don't think there's much to recover from in that
Remember,
point.
you're supposed to have been broke.
Well,
if you had
sure,
it.
but say somewhere along the line you won the lottery. I mean, you never know. Inherited some money.
Well, you have to resubmit applications regularly. So somewhere along the way there would have been fraud.
Well, sure.
Yeah. Yeah.
Not that there's ever Medicaid fraud.
Oh, no,
right.
no.
Well, and it's something to think about too. And I see it. This isn't just a parents planning issue. This is a family planning issue, because if your parents are on Medicaid and in a nursing home, and you pass away and you don't have kids, I don't have kids, and so my parents stand to inherit from me when I pass away by the laws of the state of Missouri. And they would they're qualified for Medicaid, so they're quote unquote broke. and they inherit money from me, and then all of a sudden they're disqualified from Medicaid, and they've got to spend the money they just got from me. Or the rich uncle scenario, if that ever comes up, which still hoping every day that my rich uncle somehow comes out of the woodwork. But it really is an entire family planning issue. And so in the children's trusts, we say, how's mom and dad? Do you want to give them some money? If so, we shouldn't give them the money directly. We should do it in a testamentary trust so that it doesn't disqualify them.
Yeah, trusts are so marvelous in so many ways. In addition to the subject we're talking about today, the idea that you can protect your children from spouses in a divorce. In other words, the assets will not be a marital asset. They will be protected if you choose to leave them in a trust versus handing them out free and clear. And having practiced domestic relations law for many years with Cordell and Cordell, I can tell you that those assets that are inherited by one spouse or the other almost invariably end up as marital assets. They don't have to technically if they're handled with an accountant's sort of precision. Nobody does that. I mean, they don't. They go out and buy real estate in joint names. They put it in a joint bank account. They commingle money that they may think, oh, if I earn money, my paycheck, I can put it in this account of my inheritance money. No, the money you earned in your paycheck is marital while you're married, which means you've commingled and probably converted over time that asset. Now it's a marital asset, and previously it was your separate asset. So you can protect your children from all these things. Lawsuits, bankruptcy. Mm-hmm. I mean, so many dangers are lurking out there. Bad judgment.
Right.
That may be the biggest danger that our children have to contend with is their own bad judgment. So why wouldn't we protect even our adult children if we know where they need protection? And so I think that trusts are a marvelous, marvelous tool for lots of things. And this is one of them that we're talking about today.
Now, what if the individual owns a business? And I'm not talking some big corporation. I'm talking some mom and pop bakery.
It adds to their net worth is the real answer. So you own a business and it's worth $500,000. Your percentage of that $500,000 is a countable asset. And so you either have to sell the business and spend the money down or do planning. I mean, the trust can hold business interests.
What if you own that business, say, with a non-relative, a friend?
It's your
percentage.
Yeah, your ownership valuation.
So that's going to affect the other owner.
Not necessarily. It just you won't be able to qualify.
Right.
I mean, they can't take the.
That's what I'm asking.
Yeah.
Can they take it?
So the state of Missouri isn't going to be this guy's business partner at the end of the day.
Okay.
Yeah, and keep in mind we're talking about assets here. In our next show, we're going to talk more about how income is handled.
Planning.
But I will say that you remember it's in the state's interest to have a spouse still have income, and even to have income that's contributed toward the person who is institutionalized. They call them the institutionalized spouse. To have money that's contributed toward that. So if they own a small business and it can keep going, Medicaid's position is that they won't count assets that are necessary to the ongoing operation of the business. And now there's room for interpretation.
Right.
But generally, if you think about it, that would be foolish because they could sell something and maybe get $50,000 out of it or $100,000 when in reality this business is maybe have the ability to throw off $15,000 or $20,000 a year, especially if or much more, if the community spouse, which remember there's an institutional spouse
and the community
and
spouse.
The community spouse.
That's the one that's at home.
Yeah, and the community spouse.
I'm learning.
As long as they're operating the business, then everybody wins. So that's an example of an asset. We didn't talk about that, did we? That might not be considered for purposes of those calculations.
No. So So you're talking about income generating assets
Yes.
are exempt, right? Yeah. So things like Medicaid qualified annuities are a perfect thing that I'm sure people have heard of that you convert. If you can convert
What's that?
So if you can convert a countable asset to a income source, the state loves that because then they're at the end of the day paying less out of the state's pocket state's coffers for the nursing home because you've got more income to pay yourself.
But there's another. We'll wait and talk about that in more detail. There's another aspect, an incredible planning opportunity with that, where you take something that the state would regard as a wonderful thing, and we use the laws in a way that we allow the spouse to benefit. But so assets, we should mention then that assets that are engaged in the production of income related to a business, those would be excluded for purposes of the institutionalized spouse's qualification. But the income, remember, you still have to contend with the income. Now, if you had income that wasn't worth the assets, and you should probably talk about that. So let's assume you have a $500,000 asset that throws off $5,000 or $2,000 a year income. Yeah, they would not let that asset be.
No, absolutely not. And the $500,000, if it can be converted to cash, the state wants you to convert it to cash and spend it down.
and just keep that in mind when we're talking about assets that might be exempt for purposes of generating income. If it's a losing proposition, if it's in the state's interest, the asset be sold versus generate income to help the community spouse as well as the institutionalized spouse pay for their Medicaid, then of course the state's going to say, let's sell the asset or let's keep the business going, whichever the state benefits more. So often you will have a business that is generating enough money to where it might be excluded so that the state gets more money indirectly.
Yeah, it's kind of trying to make the argument of, I have $1 million worth of Apple stock. It's generating dividends, so I don't have to sell that. Well, it's not generating enough dividends to pay your nursing home care, so the state doesn't. They're not going to let you keep that.
Okay.
Yeah, and one thing before we wrap up. So and this is more related to, we want to be sure and cover today more about the asset question. And we'll talk next time more about the income aspect of this, which is really more interesting, I think. But on the asset side, when you come in to make your application, you have to meet certain criteria, and that's a critical date that you need to know because that's the date that applies for purposes of calculating the look-back period for certain other key qualifications. And that date is hugely important, and it will always be the same. And we should probably take a few minutes and have you talk about that.
Yeah, are you referring to the snapshot date?
Yeah.
The date is kind of the date of application. So you submit to Medicaid. This is our application. This is our value, our net worth that we want you to consider. And so obviously, if it's a single applicant, the rules are a little bit more straightforward. But if there's an institutionalized spouse and a community spouse, a stay-at-home spouse that's healthier, still living at home, that snapshot date is really important, especially in the state of Missouri, because they'll take the total number of your assets and they divide them in half. If that number is $130,000, then the spouse can keep that entire $130,000, and then the other half has to be spent down as the institutionalized spouses. But if the total value of assets is $130,000 or less, the community, there's no spend down. And so that snapshot date is really important as far as determining eligibility and determining what a community spouse can keep.
And that snapshot date is going to be the date upon which this 60-month look-back period is based. And that's going to be true whether or not you actually enter a nursing home.
And that's when the clock starts ticking.
That's when the clock starts. So it doesn't have to be the date that you enter a nursing home. As a matter of fact, if you entered a nursing home without the expectation that you'd be there for at least 30 days, then that wouldn't even start the clock. So it's an important date. We won't dwell on it a lot here, but we want you to understand that there's a moment in time when you want to be sure that your best position on your balance sheet, the form you fill out for the state, so that you can make the best case possible. And sometimes the planning will have you moving around some of those assets before that date so that when that picture is taken, snapshot date, so that on that date when you fill out those forms that you'll have the best possible picture you can. And we'll talk a little bit more about that next time, but I just wanted to introduce that idea of a snapshot date. We're going to wrap up this topic. I know it's a little complicated. We don't expect you to get all of this, but we expect you to get at least 75-80% of what we talk about here. That's our goal. We try to keep it simple, and that's enough to make dramatically better decisions in your life related to covering your long-term care costs. So until next time, Jim, you're a fountain of information. Jim will be back. We'll pick up for another episode talking about long-term care. So this has been another episode of Elder Talk. Till next time, take care.
You've been listening to Elder Talk with TuckerAllen, providing intelligent answers for those thinking about their future, with Attorney-CPA Joe Cordell. Sponsored by TuckerAllen, your estate and elder law advisors. For more information, visit TuckerAllen.com. Listen again next Saturday for another edition of Elder Talk with TuckerAllen. The choice of a lawyer is an important decision and should not be based solely on advertisements.